Hi there, you're listening to 99.1 FM on CJAM. Welcome back to this week's PBSC Magna Carta, featuring a special collab event with the Undergraduate Mock Trial Association at the University of Windsor.
Magna Carta is a show run by the Pro Bono Students of Canada, Windsor chapter at the University of Windsor Faculty of Law. PBSC is on a mission to provide free legal support to people and communities facing barriers to justice. With 22 chapters throughout Canada, we are the largest pro bono organization in the country. Our goal with this program is to provide you all with accessible information about relevant legal issues affecting our community.
UMTA is dedicated to fostering a passion for law, advocacy, and critical thinking among undergraduate students at the University of Windsor.
Through competitive mock trials both in-house and outside of Windsor, mentorship, and experiential learning, we aim to develop students' legal knowledge, communication skills, critical thinking, and ethical leadership.
Our mission is to provide a platform that empowers students to engage with the law, build confidence in public speaking, and prepare for future careers in law and related fields.
Before we begin, I'm your co-host, Clara, a 1L dual JD student. This is my first time working with PBSC, and I am very excited to work with my peers in increasing access to justice for people in the Windsor community.
And I'm your co-host, Sofiya, a 1L dual JD student at the University of Windsor in Detroit Mercy. This year, I'm excited to work with the PBSC to support our community and the people of Windsor.
And I'm your co-host, Natlia, a third-year undergraduate philosophy student. I am this year's UMTA president, and I am excited to partner with PBSC and CJAM as a future law student with a passion for promoting accessibility to justice.
And I'm your co-host, Gabriella Mayo. I'm a third-year communications student, and I'm this year's vice president of events and coordination for UMTA. I'm super excited to be working with PBSC and CJAM. I'm very passionate about the law, and I'm always looking for opportunities to advocate for social justice and equality.
Today we are going to follow a traditional moot. This moot problem is an appeal of an arbitration decision that will be heard by the Windsor Court of Appeal. The appellant, Jayana, used to work for the respondent, Coffin Industries, and claims that she was discriminated against when she was terminated. The primary issue is whether or not the respondent met its obligations under the Ontario Human Rights Code. The parties are also in disagreement as to how much notice the respondent is entitled to in light of her without cause termination. The appellant believes that there is a pervasive racial bias in the industry and that this should have influenced her former employer's actions and entitled her to a longer notice period. Without further ado, we will begin the moot.
Today, I will discuss how Coffin Industries violated Section 5.1 of the Ontario Human Rights Code. We will look at 3 critical points. First, how Coffin Industries failed to comply with its duty to prevent race and sex discrimination under Section 5. Next, how various supervisors at Coffin Industries were complicit in violating the harassment clause through microaggressions, normalizing this behavior within the company. And finally, how Coffin Industries dismissed and failed to take seriously the complaints of its employee, Jayana Holiday. Each of these points demonstrates the systemic failure within Coffin Industries to protect Jayana Holiday from discrimination and harassment, contrary to the legal obligations imposed by the Ontario Human Rights Code. Section 5.1 of the Ontario Human Rights Code mandates that every person has the right to equal treatment with respect to employment without discrimination because of race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, age, record of offenses, marital status, family status, or disability. Coffin Industries violated this fundamental right by failing to protect Jayana from race-based and gender-based discrimination. From the outset, Jayana experienced racial microaggressions, such as Dwight Schrute's comment that her accent was difficult to understand. Such remarks are not innocuous. They are part of a larger pattern of racial discrimination. Accent discrimination has long been recognized as a form of racial and ethnic discrimination, as noted in the case Payne v. Otsuka Pharmaceutical Co. In this case, the Ontario Human Rights Tribunal found that dismissing an individual outright because of a perceived difference in language or manner of speaking linked to racial background was a violation of the Human Rights Code. The second layer of discrimination involved sex. Dwight's repeated unfavorable comparison of Jayana to her white male predecessor, Kevin Malone, was not just biased, but also reflected entrenched sexist and racist stereotypes about what a successful employee should look like. This pattern of treating Jayana differently from her white male colleagues without addressing the racial and gender undertones shows that Coffin Industries failed to meet its obligations under Section 5.1. The Ontario Human Rights Tribunal has previously ruled that employers must not only prevent direct discrimination, but also address indirect forms of discrimination, such as microaggressions or differential treatment based on race or sex, as seen in Nelson v. Lakehead University. There, the tribunal emphasized that employers must actively prevent and correct all forms of discrimination in the workplace. Next, various supervisors at Coffin Industries were complicit in violating the harassment clause through their normalization of microaggressions. Microaggressions, those subtle, often unconscious comments or actions that reinforce racial or gender stereotypes, are harmful forms of harassment that, when unchecked, create a toxic work environment. The failure to address or even acknowledge microaggressions is a violation of the employer's duty to prevent harassment under Section 5.1. One significant microaggression occurred when Dwight openly questioned Jayanna's ability to relate to her colleagues due to her not participating in conversation about yachts and sailing, a thinly veiled suggestion that she didn't belong in elite, predominantly white spaces. Jayanna's response that these were privileged topics were dismissed, and Dwight later lodged a formal complaint against her, adding that she wasn't a good fit for the role. The failure of Lena Morris, Jayanna's direct supervisor, to intervene or challenge Dwight's action made her complicit in the continuation of the discriminatory treatment. Microaggressions can be as harmful as overt discrimination, as they perpetuate stereotypes and contribute to a hostile work environment. In Bagaya v. Daydem International Ltd., the tribunal emphasized that harassment, including subtle acts of discrimination, should be promptly addressed by employers. Coffin Industries, through its management, normalized this discriminatory behavior, allowing it to persist without challenge. In fact, Lena reassured Jayanna that Dwight was simply difficult to please and dismissed his complaints as routine. By failing to take these microaggressions seriously, Lena and other supervisors at Coffin Industries failed to meet their duty to prevent a poisoned work environment. And lastly, Coffin Industries' failure to take Jayanna's complaint seriously. After enduring repeated discriminatory comments and treatment from Dwight and Michael Scott, Jayanna raised her concern with her supervisor, Lena Morris. However, these complaints were dismissed or downplayed. Lena even acknowledged that Dwight had a reputation for making complaints about new account managers. Yet, she did nothing to protect Jayanna from his racially charged behavior. This failure to investigate or address complaints is a clear violation of Coffin Industries' obligation under the Human Rights Code. As established in Nelson v. Lakehead University, employers have a duty not only to prevent discrimination, but to also investigate complaints when they are raised. The tribunal in Nelson made it clear that an employer cannot simply sit idly by when allegations of discrimination are made. An employer's failure to investigate or take appropriate action makes the protection provided by the code meaningless. Even after Jayanna raised Dwight's offensive comment about her accent and the racial slur she overheard, Coffin Industries took no meaningful action. Instead, they terminated her employment following a third complaint, despite the fact that the complaints were based on biased and discriminatory views. By not acting on her complaint and treating them as routine or unimportant, Coffin Industries allowed a culture of racial harassment to persist. In Payne v. Otsuka Pharmaceutical Co., the tribunal reinforced the importance of taking complaints seriously. In that case, the failure to investigate and properly address discriminatory behavior allowed the discrimination to continue unchecked, just as it did in Jayanna's case. Coffin Industries had an obligation to create safe, discrimination-free work environment, but instead, they ignored Jayanna's concern and dismissed her from her role. In conclusion, Coffin Industries violated Section 5.1 of the Ontario Human Rights Code by failing to prevent and address both race and sex discrimination. Supervisors like Lena Morris were complicit in enabling and normalizing microaggressions, and the company dismissed Jayanna's complaints of discrimination without investigation. This failure to act not only harmed Jayanna, but also set a dangerous precedent for how marginalized employees are treated within client-facing industries. The tribunal has made it clear that the protection under the Human Rights Code is not just a passive duty. It requires active engagement from employers to address and correct discriminatory behavior. Coffin Industries failed at every step to meet this duty. The Human Rights Code exist to prevent exactly this type of mistreatment, and we must ensure that it is enforced to protect employees like Jayana from future harm. Thank you.
My name is Clara, and I'm here today on behalf of the appellant, Jayana Holiday, in the case at bar. I will be arguing, due to the pervasive racial bias and bias in office industries, Ms. Holiday was warranted a longer notice period and is entitled to 8 to 10 months of pay in lieu of notice. I will also be referencing Bardell v. Globe and Mail Ltd. and several precedents to prove the appellant deserved a longer notice period according to Bardell factors. Ladies and gentlemen, we are here today to discuss the detriments, challenges, and discrimination the appellant, Ms. Holiday, faced at her workplace. As you all know, Ms. Holiday is a successful Black Afro-Caribbean woman with a BA in computer science and a graduate degree in artificial intelligence. For 9 years, Ms. Holiday served as a respectable, successful, and loyal employee in Coffin Industries, a company known for cultivating long-standing relationships with industry leaders. On December 1st, 2020, Ms. Holiday was promoted to account manager, a position offered to her in light of her experience and success within the company. For 8 years, Ms. Holiday maintained healthy work relationships and never received complaints about her behavior or work ethic. It was not until January 5th, 2021, where Ms. Holiday independently organized a welcome lunch with her primary contacts, that she unfortunately encountered 2 racist clients, Michael Scott and Dwight Schrute, who developed an unwarranted vendetta against Ms. Holiday. After several months of working together, Ms. Holiday received 3 complaints from Mr. Schrute and Mr. Scott, which resulted in Ms. Holiday's dismissal in accordance with their customer relations policy, which reads, "Here at Coffin Industries, client service and reputation are critical to our success and of the utmost importance to us. Accordingly, any employee who receives 3 distinct formal complaints from any of our clients or business partners is subject to disciplinary action up to and including termination. In particular, employees who are in client-facing roles are held to the highest standard and are therefore subject to harsher disciplinary measures." I think before continuing, it's important to define what a complaint actually is. A complaint is a statement that a situation is unsatisfactory or unacceptable. Considering the appellant's experience, positive reviews, and treatment towards and from her colleagues, I will not qualify Mr. Schrute's and Mr. Scott's ridicules as complaints, but instead state them as they are: prejudice. As such, each and every prejudice claim by Mr. Schrute and Mr. Scott should not have been considered complaints to begin with. After 3 superficial and substantive prejudices, Ms. Holiday was terminated without cause. This case is not only exemplary of a critical issue in discrimination in the workplace against BIPOC, but it amplifies a crisis in fair treatment in the workplace when racial bias and bias is involved. When looking at the factual evidence of the case, it is clear there is a pervasive racial bias at Coffin Industries, and this influenced Ms. Holiday's former employer's actions, thus entitling her to a longer notice period. Prior to accepting her new role, Lena Morris, the Chief Operating Officer, informed Ms. Holiday that there was a particular portfolio of clients that have a history of being difficult to work with. This raises the question as to how many rights Mr. Scott and Mr. Schrute violated in the workplace. How many times were people who studied and worked for years to obtain their dream job discriminated against and frightened to return to work the next morning? The first prejudice brought before Ms. Morris was by Mr. Schrute, who made comments about Ms. Holiday's goal for healthy business relationships or lack thereof, and her accent, which my partner already emphasized, was completely unwarranted and an act of discrimination. It is to the appellant's dismay that Ms. Morris behaved completely biased towards Mr. Schrute, If Miss Holliday did not want to continue to develop healthy business relationships, she would not have organized a welcome lunch to begin with. Miss Morris, in her meetings with Miss Holliday, reassured her that she was not the problem. Yet, she did not bother to investigate the matter and completely overlooked Mr. Schroot's unjustified and unnecessary comment regarding Miss Holliday's accent. By recording a clear prejudice as a complaint and refusing to investigate, it is undoubtedly obvious that Miss Morris values Mr. Schroot and Mr. Scott, two men with a history of difficult behavior, over Miss Holliday, a successful woman with no history of misconduct behavior. When Miss Holliday was terminated on a without cause basis, Miss Morris admitted Dwight had a racist reputation and formally stated she was not sure how to handle Mr. Schroot and Mr. Scott, as they were very important clients of the company, not only emphasizing that Miss Morris values the company's reputation over the well-being of their employees, but contributing to the bias in the industry. By admitting she was aware of the racist behavior taking place within Coffin Industries and doing nothing, it is evident Miss Morris is not fit to be in her position of power, and Miss Holliday should not have been terminated by someone who would rather ignore a clear violation of charter rights in their workplace than involve herself in justice. According to case law, Payne v. Otsuka Pharmaceutical Co., this is a third-party discrimination case which outlines the duty to inquire and investigate. Miss Payne, a black woman, was denied a job of booth receptionist for Mr. Otsuka by Mr. Okada because she is a black. The board found this to be legitimate, and a clear prima facie case was made. According to the facts of the case, there is evidence that Mr. Okada made racial comments about Miss Payne behind her back, similar to the racial slurs Mr. Schroot and Mr. Scott made prior to their second complaint about Miss Holliday. Miss Payne also had a very good reputation and was more than qualified for the position. She was treated poorly and discriminated against strictly on the basis of her skin color. Also, like Mr. Schroot, who compared Miss Holliday to Kevin, a middle-aged Caucasian man, Mr. Okada requested a Miss Michelle Gay, someone he thought was, as he quoted, the right girl. It was proven in this case that there was a human rights duty not to condone or further discrimination. The board found that the Ontario respondents did not meet their duty to investigate such racist behavior. I believe, according to the facts of the case at bar, the court will find that Coffin Industries also failed their duty to investigate a series of pervasive racial bias in the company. In Bagaya v. Datum International Ltd., an employer cannot be said to have failed to investigate or respond to an allegation of discrimination where an employee fails to properly and specifically make a complaint. Similarly to Miss Holliday, Bagaya, who identifies as a black man, argues he was discriminated, harassed, and was terminated without cause from his employment. Although a part of the application was dismissed, this case is very important as it emphasizes the duty to investigate. Section 5 of the Employment Code imposes a duty on employers not to condone or further a discriminatory act that has already occurred and to investigate a complaint of discrimination. In this case, the tribunal references Nelson v. Lakehead University. In the case at bar, multiple pieces of evidential facts point to the contention that Miss Morris was aware of the discrimination occurring at Coffin Industries and not only failed to investigate but condoned it. It is thus proven that the workplace to which Miss Holliday was employed was not a discrimination-free zone and was actually a harmful environment to employees. Following these submissions, the denial that Miss Holliday was terminated based on racial factors is disheartening. Therefore, according to case law, there was a failure of duty to investigate, a violation of basic employment rights according to the Constitution Act of 1982, and a failure of a reasonable notice period according to Bartle factors. With reference to Bartle v. Globe and Mail Ltd., There can be no catalog laid down as to what is reasonable notice in particular classes of cases. The amount of reasonable notice is a question of fact, to be decided in each case, having regard to the character of employment, the length of service, the age of the employee, and the availability of similar employment, and the determination of which the experience, training, and qualifications of the employee are taken into account, as well as any other factors peculiar to that case. Depending upon the facts of the case, other factors which may apply in determining the length of reasonable notice include whether the dismissed employee was induced to leave previous secure employment. Arriving at a reasonable notice period is thus not as formulaic as it is sometimes made out to be. Bartle factors include years of service, age, character of employment, and availability of similar employment. Due to COVID-19, the later factor will be significant. To summarize, Miss Holliday worked for Coffin Industries since 2013. Upon her termination in late 2021, she is 28 years old and has a positive character of employment noted by multiple people, including Chief Operating Officer Lena Morris. Due to the pandemic, many businesses and job opportunities were negatively impacted. Even though the tech industry remained relatively stable, that is not to say it is presently stable in Windsor, where the appellant plans on moving to be closer to her family. Further, most of the jobs currently available to Miss Holliday require applicants with business backgrounds. Thus, even though Miss Holliday is a highly qualified individual, she does not come from a business background and is automatically a less considerable applicant for her desired positions. Following Kendra v. Tesla, a 27-year-old woman who worked as a senior software developer and team lead for 7 years, she was awarded 4-month notice because there was an unusual high need for software developers during the time of Miss Kendra's termination. The second precedent, Angela v. Google, follows a 62-year-old woman who worked as an account manager for 14 years. She was awarded 14 months to find a new position because she was unlikely to find similar employment given her age and gender. The third precedent is Charles v. Amazon. He is a 32-year-old male who worked as a software engineer for 5 years. He was awarded 11 months. Chris v. Apple follows a 21-year-old child prodigy who worked as a chief technology officer for 1 year. He was awarded 9 months. AJ v. Microsoft follows a 28-year-old male who worked as a software engineer team lead for 5 years. He was awarded 10 months because there were fewer comparable positions available at the time. What these precedents have in common is based on Bartle factors. These employees were all awarded sufficient and reasonable time to obtain new employment, a legal right to which Miss Holliday was denied. These precedents further prove Miss Holliday was treated unfairly and is due 8 to 10 months of pay in lieu of notice. Miss Holliday was a very influential individual at Coffin Industries, having been there and serving as a loyal employee for almost 10 years alone should have granted her more than 4 months to obtain new employment. She is almost 30 years old, who will compete with older, more experienced individuals, thus entitled to a longer notice period. Her character of employment is indistinguishable. She is an experienced individual, thus will compete for more competitive positions, which are not always readily available. Given the fact that she is a woman, and a black woman at that, she will, unfortunately, automatically have more difficulty to obtain a new position, given the racial and gender bias in the employment industry. According to statistics, 1 in 10 women are prejudiced against in the workplace, where less than 1 in 20 men face the same fate. Finally, Miss Holliday does not have the qualifications for another position, but the availability of similar employment is not readily available given the tragedy of the pandemic. Therefore, the appellant respectfully requests the Windsor Court of Appeal to allow the appeal and determine whether Coffin Industries violated Section 5 of the Ontario Human Rights Code, and if Ms. Holiday was warranted a longer notice period with the entitlement of 8 to 10 months of pay in lieu of notice. This completes the arguments on behalf of the appellant.
Hello, my name is Natlia Cervenkovsky, and today we are here to defend the integrity and fairness of Coffin Industries, a company known for its commitment to diversity and ethical business practices. The appellant, Ms. Gianna Holiday, claims she was the victim of race and gender discrimination. But these allegations are not grounded in reality. Coffin Industries did not turn a blind eye to Ms. Holiday's concerns. In fact, the company provided her with the support and clear opportunities to address any discomfort she experienced. However, Ms. Holiday chose not to formally report the issues she now claims were central to her termination. The facts will show that Coffin Industries acted fairly and adhered strictly to its customer relations policy, a policy applied uniformly across the company. Ms. Holiday's termination was based on clear and documented client complaints, not bias. As we delve into the details, it will become clear that the appellant's claims are vague, unsupported by evidence, and fail to meet the legal standard for discrimination. Therefore, we ask that the court recognize Coffin Industries' adherence to the law and dismiss the appellant's unfounded claims. I will now address the first issue before this court: whether Coffin Industries violated Section 5, Subsection 1 of the Ontario Human Rights Code, which guarantees all employees the right to equal treatment in employment without discrimination based on race, gender, or other protected grounds. Coffin Industries is a reputable, multinational corporation that provides IT services. It is a company that is well known for cultivating long-standing relationships with industry leaders and prides itself on its reputation for stellar client service. The appellant, Ms. Gianna Holiday, alleges that Coffin Industries fostered a discriminatory environment, claiming she was subjected to both race and sex discrimination, and that her complaints were ignored. However, we contend that Coffin Industries fully adhered to the Ontario Human Rights Code and took reasonable steps in handling Ms. Holiday's concerns. The evidence does not support the notion that the company condoned or allowed discrimination to occur unchecked. First, it is important to understand the nature of the relationship between Ms. Holiday and her supervisors, particularly Ms. Lena Morris. Ms. Morris, the chief operating officer to whom Ms. Holiday reported, demonstrated a pattern of supportive and fair behavior. When Dwight Schrute, a representative from Facebook, made a formal complaint about Ms. Holiday in February 2021, Morris did not react in a punitive way at all. Instead, she reassured Ms. Holiday that Mr. Schrute had a reputation for being hard to work with and that there was no reason for her to worry. Morris emphasized that Ms. Holiday had a strong reputation at Coffin Industries, and the complaint would not be held against her in any way. The appellant argued that Coffin Industries allowed racial microaggressions to go unchallenged, particularly pointing to comments made by Mr. Schrute about Ms. Holiday's accent and a racial slur she overheard at a client meeting. While these incidents are unfortunate, the critical point is that Ms. Holiday did not formally raise these issues through the company's diversity and inclusion policy. This policy was specifically designed to address discriminatory behavior within the workplace. Yet, Ms. Holiday did not at all utilize this process. Coffin Industries, then, cannot be held responsible for failing to address complaints that were never formally made. Morris, despite being aware of Mr. Schroot's difficult personality, did not have the full context of the racial issues Miss Holliday claims she faced because they were not reported. This brings us to the relevant legal precedent. Bagaya versus Datum International Ltd., a 2010 decision from the Human Rights Tribunal of Ontario. In this case, the tribunal ruled that an employer cannot be liable for failing to address discrimination when the employee fails to report the issue properly. The tribunal emphasized that formal complaints provide the employer with an opportunity to investigate and take appropriate action. Without such complaints, the employer cannot be expected to address potential discrimination. This case is directly applicable here. While Miss Holliday may have felt uncomfortable or targeted by Mr. Schroot and his colleagues, she did not follow Coffin Industries' prescribed process for raising complaints. Therefore, the company cannot be blamed for failing to act on issues it was unaware of. Additionally, the plaintiff's allegations lack specificity. Miss Holliday has not detailed how her termination was discriminatory, nor how the client complaints were based on her race or gender. Miss Morris was unaware of the allegations before making the termination decision, which was based on the company's 3-strike consumer relations policy. Without specific allegations and formal complaints, the company cannot be held accountable for the subjective feelings of discrimination that Miss Holliday raises after her termination. Furthermore, the plaintiff has failed to meet the legal standard required to prove discrimination. Miss Holliday has not provided concrete evidence demonstrating discriminatory intent by Coffin Industries. As per the Ontario Human Rights Code and established case law, the burden of proof lies with the appellant to show that the employer's actions were motivated by discriminatory factors. In contrast, the plaintiff's claims lack evidence to meet this specific standard. Case law such as Payne versus Otsuka Pharmaceutical Co. confirms that subjective feelings of discrimination are not enough. There must be clear proof of intent beyond a reasonable doubt. Coffin Industries, in this case, based its termination decision on formal client complaints and the consistent application of company policy, not at all on any discriminatory grounds. It is also critical to address the broader corporate environment at Coffin Industries. The company had policies in place to prevent discrimination and harassment, including its customer relations policy and diversity inclusion policy. These policies were designed to protect employees like Ms. Holliday from unfair treatment and to ensure that any issues were investigated thoroughly. When Ms. Holliday was terminated, it was based on the company's customer relations policy, which clearly states that employees who receive 3 distinct formal complaints from clients are subject to disciplinary action up to and including termination. The fact that Ms. Holliday was terminated after 3 formal complaints is not evidence of discrimination. It is evidence of the company applying its policies uniformly. Additionally, during Ms. Holliday's termination meeting with Morris and Pam Beasley, the head of Human Resources, Morris acknowledged Ms. Holliday's concerns about past racial incidents, but reiterated that no formal complaints had been made. Beasley also pointed out that the company's diversity and inclusion policy was clear about how to report such issues. Had Ms. Holliday raised her concerns earlier, Coffin Industries would have had an opportunity to address them. Instead, Ms. Holliday waited until after the third client complaint to mention her discomfort, limiting the company's ability to respond effectively. In conclusion, the evidence demonstrates that Coffin Industries took reasonable steps to support Ms. Holliday and address her concerns when they were raised. The allegations made by the appellant lack specificity, and she has not met the legal standard required to prove discriminatory intent. Coffin Industries cannot be held liable for issues that were never formally brought to its attention. Coffin Industries adhered to the Ontario Human Rights Code and took appropriate action based on its policies. We respectfully ask the court to dismiss the claim that Coffin Industries violated Section 5, subsection 1 of the Code, as the evidence does not support this allegation. The company acted fairly and in accordance with its legal and ethical obligations.
Hello, my name is Gabriella Mayo, and the question of Ms. Holliday's notice period is at the heart of our discussion today. The appellant may argue that she deserved more than the 4 months of notice awarded to her, but the truth is, this notice period was generous and entirely appropriate under the law. Ms. Holliday is a young, ambitious professional with highly marketable skills in the tech industry, an industry that has proven resilient and filled with opportunity, even in challenging times. The facts of this case show that Ms. Holliday, at just 28 years old, with 8 years of service and significant experience, is in a prime position to quickly secure new employment. The 4-month notice period reflects her role, her age, and the abundant job opportunities available to someone with her qualifications. The appellant will paint a picture of unfair treatment, but the reality is Coffin Industries followed the law to the letter, and Ms. Holliday has not been disadvantaged in any way. The arbitrator's decision was well-reasoned and fair, and we respectfully ask the court to uphold it. Extending the notice period would be an unwarranted departure from legal precedent and fairness. Now, I will turn to the second issue, which concerns the notice period Ms. Holliday received upon her termination. Ms. Holliday was awarded 4 months of notice, and we argue that this was not only reasonable, but also entirely appropriate based on the Bartle factors and the applicable case law. The appellant contends that the notice period should have been longer, citing bias and systemic discrimination. However, when we apply the Bartle test to Ms. Holliday's situation, it becomes clear that the 4-month notice period was fair and well within legal standards. Let us begin by analyzing the character of employment, which is one of the key factors in the Bartle test. Ms. Holliday held the position of account manager at Coffin Industries, a managerial role involving client relations and strategic planning. While this position was certainly important, it was not at the highest executive or leadership level. Ms. Holliday did not have direct reports, and her role, while influential, did not involve making company-wide decisions. The Bartle factors recognize that senior executives and high-level managers, whose roles are harder to replace, often receive longer notice periods due to the complexity and scope of their responsibilities. Ms. Holliday's role, although significant, does not rise to this level. Therefore, her position warrants a reasonable notice period, but not one that would be comparable to that of a senior executive. Next, we must consider Ms. Holliday's age and length of service. Ms. Holliday was 28 years old at the time of her termination, and she had been with Coffin Industries for 8 years. And while 8 years is a substantial amount of time, it is important to note that age plays a critical role in determining the length of notice. The Bartle factors emphasize that older employees typically receive longer notice periods because they are expected to have more difficulty finding new employment. Ms. Holliday, on the other hand, is still relatively young, and younger employees are often more adaptable and able to secure new positions more quickly. At 28, Ms. Holliday is in the prime of her career, with substantial skills and experience in a high-demand industry. As such, the 4-month notice period is in line with what is typically awarded to younger employees with similar years of service. The availability of similar employment is another key factor under the Bartle test. The tech industry, as we know, remains relatively stable even in the wake of the COVID-19 pandemic. The agreed-upon facts indicate that there are ample opportunities for someone with Ms. Holliday's skills and experience in the Toronto area. Her background in computer science, artificial intelligence, and client relations makes her a highly desirable candidate in the tech sector. While Ms. Holliday has expressed a desire to move back to Windsor, the availability of remote work and the demand for tech professionals means that her job prospects remain strong regardless of location. There is no indication that she would face significant difficulties in securing a new role, particularly in an industry that continues to thrive. Precedent also supports this view. For example, in Kendra v. Tesla, an employee with 7 years of service in a managerial role was awarded 4 months of notice. The court's reasoning was based on the stability of the tech industry, the employee's relative youth, and the availability of similar positions. Ms. Holliday's case is strikingly similar. She, too, is a young professional with substantial experience in a managerial role, and the tech industry continues to offer abundant opportunities for someone with her qualifications. The 4-month notice period awarded to Ms. Holliday is entirely consistent with this precedent and reflects the reasonable amount of time she would need to secure similar employment. In a high-demand field like technology, where her skills are highly valued, the availability of positions would allow her to transition smoothly into a new role within this time frame. Let us also consider the Bartle factors in the context of fairness and precedent. The notice period is meant to provide employees with enough time to find new work that is comparable to the role which they held before termination. It is not intended to be punitive to the employer, nor should it be extended based on subjective feelings of unfairness. In this case, the 4-month notice period was calculated based on objective factors: Ms. Holliday's role, her age, her length of service, as well as the availability of similar jobs. The arbitrator carefully considered these factors and arrived at a reasonable decision that aligns with both legal precedent and the specific circumstances of the case. there is no evidence to suggest that Ms. Holliday was disadvantaged by the notice period she was given. On the contrary, it reflects a fair balance between her need for time to find new work and Coffin Industries' obligation to provide reasonable notice. In conclusion, the 4-month notice period awarded to Ms. Holliday was entirely appropriate. It is consistent with the Bartle factors, which take into account her age, length of service, the nature of her employment, and the availability of similar roles. The arbitrator's decision aligns with legal precedents, particularly Kendra v. Tesla, and provides Ms. Holliday with a fair and reasonable amount of time to secure new employment. We respectfully request that this court uphold the arbitrator's decision and reject the appellant's claim for a longer notice period. The notice period reflects a well-reasoned application of the legal standards, and extending it would not be justified based on the facts of this case. Coffin Industries fulfilled its obligation under the Employment Standards Act, and the 4-month period is sufficient to ensure that Ms. Holliday has time to transition to new employment. Thus, we respectfully ask the court to uphold the arbitrator's ruling. The 4-month notice period is not only in line with the relevant legal precedents, but also fair given the circumstances. Coffin Industries has acted within the framework of the law, and the decision should stand as a just application of the Bartle principles to this case. Thank you.
All right, that concludes the moot. Thank you so much for listening to us debate as the appellant and respondents. We hope this introduction to mooting was valuable to you. We will now explore the topic of employment rights.
Employment rights are so crucial, especially when it comes to ensuring there's no racial bias in the workplace. It feels like a fundamental part of making sure that people are treated fairly, don't you think?
You're absolutely right. Employment rights are like the foundation that helps ensure no one is discriminated against, whether it's during hiring, promotions, or even day-to-day interactions at work. In Ontario, the Human Rights Code is the key piece of legislation that guarantees equal treatment in employment, regardless of someone's race, ethnicity, or color. That's a big deal because it protects people from facing unfair barriers just because of who they are.
And it's not just about hiring, right? Like, the issue of racial bias can show up in all sorts of ways. Pay differences, fewer promotions, or even in how employees are disciplined. I imagine it can be subtle sometimes.
Exactly. Racial bias can be both explicit and subtle. For example, a company might have policies that apply to everyone on the surface, but if those policies end up disproportionately affecting a particular racial group, that could still be considered discriminatory. That's what we call constructive discrimination. Even if an employer doesn't intend to discriminate, the impact of their actions can still be harmful.
Right, and that's where diversity and inclusion come into play. It's not just about avoiding blatant racism, but also about creating a workplace where everyone feels included and valued, regardless of their background.
Exactly. Employers have a responsibility to actively work toward eliminating bias, not just complying with the law. That's why diversity and inclusion programs are so important. They help address the more subtle forms of bias that can exist in the workplace. But if things go wrong and someone feels they've been treated unfairly, that's when knowing your rights becomes really important.
Yeah, but I imagine it's not always easy to come forward if you're facing discrimination. Like, even if you know it's wrong, the fear of retaliation or losing your job could stop you from saying something.
That's definitely a concern. But the good news is that Ontario law has protections in place to prevent that. The Human Rights Code prohibits retaliation against employees who make a complaint. So, if someone reports discrimination or racial bias, their employer can't legally punish them for speaking up. And if they do, that's another violation of the code.
It's great that those protections exist, but I'm sure some people still feel hesitant. If someone feels like they're experiencing racial bias, where can they go for help, especially around here in Ontario or Windsor?
There are a few really important resources. First off, if someone thinks their rights have been violated, they can file a complaint with the Human Rights Tribunal of Ontario. The tribunal handles cases where discrimination has occurred, and they can investigate and even order remedies like compensation if needed. For people who aren't sure how to start or need legal advice, there's the Ontario Human Rights Legal Support Centre. They offer free legal services to help individuals navigate human rights claims, and they can assist with everything from preparing a case to representation.
That's really useful, especially for people who might not have the resources to hire a lawyer on their own. What about Windsor? Are there any local organizations that can help?
Absolutely. In Windsor, people can turn to Legal Assistance of Windsor or Community Legal Aid. Both provide legal help with employment issues, including discrimination claims. They have great options for anyone who needs legal support, but might not be able to afford private legal representation. And beyond legal assistance, there's also the Canadian Mental Health Association, CMHA, here in Windsor. They offer mental health support, which is really important for people dealing with the emotional impact of workplace discrimination. It can be draining to experience racial bias at work, so having that kind of support makes a big difference.
That's a good point. I can imagine that dealing with racial bias isn't just a legal issue. It takes a toll on your mental health too. It's good to know there are resources beyond just legal help.
Definitely. Addressing discrimination holistically means offering both legal and emotional support, and many workplaces are starting to catch on to that too. Some now have diversity and inclusion officers, or teams that handle these kinds of issues internally. These people can be a valuable resource for employees who don't feel comfortable going straight to legal action, but still need help navigating these situations.
That's a great option, especially in companies that are genuinely trying to improve. But I guess if things are really bad or there's no internal support, that's when you need to escalate it, right?
Exactly. If the internal processes aren't working or if the bias is systemic, escalating to the tribunal or getting legal advice is definitely the way to go. The other thing to consider is that unions, if you're a part of one, can be really helpful too. They're often involved in advocating for fair treatment that can help employees with these kinds of issues.
It's good to know there's so many places to turn to. Sometimes it feels like it's just you against the system, but it sounds like there's a lot of support out there, both legally and emotionally.
There is. The laws in Ontario are designated to make sure people have a fair shot, and the resources are there to back it up. But you're right. Facing discrimination can feel isolating. That's why it's important for people to know they don't have to go through it alone. Whether it's the tribunal, legal aid, or mental health support, there are people who can help.
It's great to hear that there's so much protection. And like you said earlier, it's not just about having these laws in place, but about building a workplace culture where discrimination isn't acceptable in the first place.
Exactly. It's about going beyond just complying with the law. The ultimate goal is to create environments where everyone is treated with respect and where racial bias simply doesn't have a place. We're not there yet, but every step toward fairness helps.
It sounds like a combination of strong laws and a real commitment to diversity and inclusion is the way forward. I just hope more workplaces take it seriously.
Me too. We've made progress, but there's still a lot of work to be done. The important thing is that people know their rights and feel empowered to speak up when something isn't right. When that happens, we can really start to see change. I'm Clara.
I'm Sofiya.
I'm Gabby.
I'm Natlia. And this is us signing off until next time on PBSC's Magna Carta on 99.1 FM on CJAM Radio.